My grandfather and great-grandfather started Junction Auto in 1931.
If you want to pay more, that's your business. If you want to pay less, that's my business.
I'm going to be frank and say it's difficult to accept that the defendant doesn't know more about how this tragic incident occurred. It certainly, and as is admitted by counsel, cannot be explained with reference to any treacherous condition. The road there is wide. The road is straight. The road is level. The road is a paved, straight, marked state highway. It wasn't dark. On the contrary, it was clear, daylight, no adverse weather conditions. The buggy was readily discernible. It displayed the slow-moving vehicle sign. There was a clear line of sight, over 1,100 feet. Ms. Pirtz didn't claim or display any sign of fatigue. So we naturally want to know why this accident happened. We know the buggy wasn't doing anything wrong. It was simply going down the road, eastbound, about 12 miles an hour. We know that the defendant apparently failed to even slow down, but simply ran into the back of the buggy at a substantial rate of speed. It's known that there was the statement referred to by Mr. Bryce, the witness behind the defendant, said there was no problem in seeing the buggy. So not many answers from that perspective. We do know the defendant's past driving record. And it's that record that on reflection displays a recurrent disregard, Ms. Pirtz, for our traffic laws, and by inference for your fellow motorists that use the road. I mean, I noted from my review of the record, 6 speeding tickets in your history, roughly 13-year history of driving. The driving under suspension charge and conviction. A failure to control accompanied by an accident. A traffic light citation, an improper turn. You want to, these, you might dispel to everybody gets a ticket now and then. These are more than just a ticket, and these aren't the serious ones. The more serious ones are the physical control of a motor vehicle while under the influence back in 2005. That is, under the influence of alcohol or drug abuse or a combination of the two. It's a serious 6-point charge, a first-degree misdemeanor, you got a license suspension. And then even more recently, much more recently, you were convicted of operating a motor vehicle while impaired with alcohol, drugs, or a combination of the two in Ashtabula County, and that was less than 18 months before this incident. Another license suspension. In that case, you refused to take a chemical test to determine the presence of alcohol or drugs of abuse in your system. Over this 13-year period, I noted 5 separate driving suspensions and 4 6-point warning letters mailed to you from the Bureau of Motor Vehicles telling you if you don't stop, you're going to lose your license. now we're here for vehicular homicide and negligent assaults. Now, the court recognizes that the victim has expressed a forgiving attitude, and the court respects the magnanimous statements of Mr. Kauffman and credits the defendant for the willingness to do what she can to help out the family. The court, however, has to look to many factors in imposing a sentence. And the court can't set aside in this case its concern for the safety of the traveling public. The court has to consider what is a fair punishment, what the impact on the victims was, the need for changing the offender's behavior, for rehabilitating the offender, and otherwise reflecting the goals of misdemeanor sentencing set forth in the code. Having considered all those factors, the court concludes that community control is not appropriate, that this situation justifies imposition of a jail sentence. And in arriving at a jail sentence, I've been mindful that these are misdemeanors. These are not felonies. And does not go to prison, cannot be sent to prison for these offenses. However, there must be some jail time, and it shouldn't be nominal either. Barbara Kauffman died in this accident, left 6 children, now 7, because she had the child after the accident. And it cries out for a sentence of more beyond a nominal sentence. On the other hand, I don't believe that the maximum should be imposed either. But given the past driving record, it's evident to me that Ms. Pirtz is really driven with an attitude of, oh well, what happens on the road happens. All of these offenses, the history shows 14 in this 13-year period, 2 of which were very serious, all the suspensions. So, while the maximum shouldn't be imposed, they need to be significant, in my judgment.